Good day and welcome to the Prosecution Matters, a podcast show brought to you courtesy of the NPA, where we'll be telling our stories of prosecuting without fear, favor, or prejudice. I am your host, Phindi Mjonondwane, and in today's topic, we try to unpack what happens soon after a case has been reported to the police. I'm joined by Advocate Matshediso Phatlanyane, a senior state advocate from the Office of the Director of Public Prosecutions in Johannesburg. Advocate Phatlanyane, welcome to the show, and thank you for making time off your busy schedule to come and talk to our viewers.
Good morning, Phindi. Thank you so much for having me. I'm happy to be here. I'm excited. So thank you for the opportunity.
Thank you, Advocate. Advocate, let's get to business. Please take our viewers through the process that unfolds soon after a case has been reported to the police. What then happens next?
Okay, thank you, Phindi. So, soon as a complainant has gone to the police office, opened a case, they will then make a statement at the police office. That will be normally firstly at the charge office. If they have a witness with them, the witness statement will also be obtained at the charge office. After the charge office, police at the charge office opened the case, it will then be entered into their CAS system, where the CAS system will generate a case number. Soon as that is done, officers from the investigative unit of South African Police Services will then come and collect the docket. It will be assigned to investigating officer. Once that process is done, SAPS will generate an SMS message that will be sent to the complainant with the case number as well as the name of the investigating officer. So if the investigating officer does, after obtaining the statement, the docket going through the statement, they'll either go back to the complainant, obtain whatever further information they need to obtain from the complainant. If the arrest needs to be made, at that time, the investigating officer feels they have enough information to make an arrest, they'll make an arrest. Once an arrest is made, the police officer has 48 hours to bring the docket as well as the suspect to court.
Okay, thank you so much for sharing that. From what you have just said now, the investigating officer will do the necessary work to populate all the necessary information compiled, put into a docket, and then that docket gets taken to court.
Correct, Phindi.
Correct. Okay, and then in an instance where there is no suspect,
yes,
what then happens?
The investigation officer will still proceed with preliminary investigations. At a time, they'll also at a point take the docket to the prosecutor. It will go to the prosecutor as a decision docket.
Oh, yes. Okay. All right. So you are saying to us that the decision whether an accused person will be formally charged and appear before court actually lies with the prosecutor. Now, once that docket reaches court, what then happens?
Can I just correct you on that? The investigating officer can arrest without the docket, having first gone to the prosecutor. But the answer was to a follow-up question of yours where you say when there's no suspect. The police officer will do whatever investigation that needs to be done, take the docket to the prosecutor to make a decision as to there's no suspect, this is the information that I've gathered, what happens then after. Okay,
and what is the role then that is played by the prosecution in terms of a docket that is brought without a suspect? I'm moving towards this term that we normally hear of prosecutorial guided investigations.
Yes. Once there'll always be a suspect or Phindi. Sometimes either the suspect is unknown or have not been found, or the police have not decided to arrest the suspect yet. But in an instant where there's no arrest that has been made, the prosecutor will go through the docket. Obviously, as a prosecutor, if there's an allegation of a certain offense, the prosecutor will go through the docket and see if there's sufficient information to meet the requirements of that offense. That's when the prosecutor guided investigations come in. The prosecutor will make an entry in the what we call the C section of the docket to inform the police officer to say, this is what I need for me as a prosecutor to say there's enough evidence for me to go charge a particular person. So once the prosecutor has guided, that is guiding our investigations, you write in the C section to say, go obtain DNA, for example, go obtain bank statements, go obtain this witness statement, go obtain CCTV footage. This is what I need. And once all those is done, the docket will then be taken back to the prosecutor. It is then when the prosecutor will decide, okay, then you can go institute an arrest.
Okay. And who gets to read these dockets in court? As soon as the investigating officer arrives, do they go straight to court to find the prosecutor, or how does it work?
With every court, a district court, there's an office what we call screening office. A screening office is an office where there's a certain prosecutor. It does not have to be a control prosecutor, an SCC, SPP, or senior state prosecutor. Every prosecutor and every decision will be assigned each day. It will be selected. For example, TD, you're going to be doing screening today. So the dockets are received at the screening office by a screening prosecutor.
Okay, and once they are received at this screening office, what is it that then the prosecutor has to establish from the contents of the docket? What is it exactly that the prosecutor will be looking for in order for them to be convinced that they have a case or not?
Okay, Phindi. So the prosecutor will, what are the allegations? Who is the complainant? What is the complainant alleging in the docket? Is there a suspect? So once for example, the prosecutor, the complainant alleges fraud, it is on the duty of the screening prosecutor to see from the statement and from what is already been gathered on the docket, from the face of the docket, is there enough evidence, at least a prima facie case against the suspect that has been pointed by the complainant based on the allegations. So the prosecutor will see if the allegations as well as the evidence that is in the docket, do they meet the requirement of a certain offense that is complained against, and if there is sufficient. Investigations does not need to be complete at that point, but we have to have at least prima facie on the face of the docket enough evidence to say to the prosecutor, yes, we have a complaint, yes, it's fraud, I see all the elements, I might need supplementary evidence after this, but at least I see this is the allegations, these are offense, this is the accused person, or this is the suspect. Once the prosecutor decides those things have been met, that is when the prosecutor will then decide to enroll the matter in court.
Okay, and in an instance then where the prosecutor decides not to enroll the matter, does that mean it's the end of the case? What then happens?
No, once the prosecutor decides not to enroll the matter, there can be two things. It can be, yes, I see there is some evidence towards an offense, but I need 1, 2, 3, 4, 5 to obtain first before I enroll this matter. It is not the end of the matter, or sometimes it can be the end of the matter, depending on what is in the docket and what is alleged. But more times, it's not the end of the matter. It's just for the prosecutor to guide the investigating officer to say, go obtain 1, 2, 3, 4, 5, and then you can come back, we can re-enroll the matter.
Okay, and quite often you find that prosecutorial decisions the perception is that they are used as a tool, maybe to, I don't want to say persecute, because the National Prosecuting Authority obviously works according to the law. But what you are saying to us is that ultimately what will convince the prosecutor is evidence that is contained in the docket. So you're not looking at who the suspect is.
No,
you are more concerned, with what is contained in the docket.
And sometimes there might be pressure for the matter to be enrolled. But like I said, there's a difference between evidence and information. There might be information that is out there, that is known, and the public might feel this person should have been prosecuted, the matter should have been placed on the roll. But as far as we work with evidence, what we can prove in court, what we can present in court. Information and evidence are two different things. We do not work based on information, but we work based on evidence that is presented to us.
And well understood. But then what would then constitute a trial ready matter?
Okay. A trial ready will be a matter that the state is ready to put the charges to the accused person. A matter will be trial ready once the prosecutor feels that all the evidence that needs to be gathered in this matter have been gathered. I have consulted with all of my witnesses, which is very important. All of my witnesses are willing and available. I've given the defense copies of the docket. They've also done their side of consultations. We've had a pre-trial conference where each party will put to the court that we are ready to proceed. We have this number of witnesses. The defense will also say we've been placed on funds, we've consulted, we're ready. So once the matter is at that stage, then it is ready for the state now to put the charge to the accused person.
Oh, okay. Now there's often this complaint, Advocate Phatlanyane, from complainants or victims of crime, that there is lack of communication. You find that the case, yes, it is enrolled.
Yeah.
I'm made aware that my case is now in court. This is the investigating officer. But then there is this lack of communication that happens, especially before a matter goes to trial. And we know that in some instances that can take a very long period. But then as the complainant, I'm kept in the dark. No one is communicating to me. So whose role is it to give information to the complainant, and how can I access such information as a complainant in a criminal case?
It's very unfortunate, Phindi, that we find instances where complainants are kept in the dark as to what is happening. But the primary role is of the investigating officer to keep the complainants involved. Because from a stage of opening a case to a stage of testifying in court, it can span a number of months, years, or even weeks. But then it's the role of the investigating officer to always keep the complainant in the loop. I think from day one, the investigating officer should inform the complainant what is to be expected to avoid frustration, because the investigating officer could have just told the complainant the matter has been postponed for investigations, but then the complainant does not really understand this might take 4 months because we're waiting for DNA evidence, which notoriously takes longer due to the backlog in our labs. So the investigating officer needs to keep the complainant well informed to avoid having to constantly check in, because if you do not constantly check in, that's when the frustration comes in, that's when the mistrust comes in. So once the complainant knows, in my case, these are the things that are needed, and the investigating officer told me these things take about 4 or 5 months. The complainant, like I said, initially when a case is open, they receive an SMS of the case number as well as the investigating officer's number. So they also are at liberty to be proactive and interested in their case and call the investigating officer once in a while to say.
Okay, let me just come in there. Sorry, Advocate Phatlanyane. But then, as the complainant, at what stage am I needed in my own case as when it is already enrolled in court? Because I'm asking this because sometimes you'll find that a complainant is complaining about the costs of going to court every time a matter has been postponed. It keeps getting postponed, and the complainant ends up paying that financial burden on them. So when exactly are they needed in court, and when do they get to meet the prosecutor that is handling their case?
Okay, Phindi. This is very important because I find that most of the time, each time an accused person comes to court, the complainant would want to come to court. And that will be at their own cost, and which can be very costly. But they mostly do this because of misinformation or lack of communication with the investigating officer. They don't know. They want to come to court to see for themselves. But the complainant only needs to come to court when they have to testify. But they're going before that. They're going to need to meet with the prosecutor that's going to be handling the trial for consultations purposes. So the only time the complainant needs to show up for court, the investigating officer should communicate with them to say, I spoke with the prosecutor, they want to see you on this particular day.
Or during your consultation.
For consultations. And then only after that, you are only needed in court when you have to testify as a complainant. All these other complainants in between, you do not have to become, because sometimes an accused person will only appear in court for 5 minutes and then they'll go home. And then you would have wasted your time. But
and sorry to come in, Advocate Phatlanyane, and then for the consultation sessions,
Yes.
how do they get support financially from the state?
For consultations, the investigating officer will transport them.
Oh, okay.
We make sure the investigating officer goes and collects them from their homes, brings them to the prosecutors' offices. We usually prefer consulting in the mornings. After that, the investigating officer will then take them home. For trial, also, for convenience, they can come on their own. They will be reimbursed financially, but ideally, we want the investigating officer also for safety purposes to collect them and bring them to court.
Okay,
Yes.
thank you so much.
But before that, they would have obviously received a subpoena, so they would have been well prepared on time to avail themselves.
And lastly, Advocate, from time to time we read in the media a case has been withdrawn, a
Yes.
case has been struck off the roll, or there's a nolly prosecute. Can you
Yes.
please just delve into these three
Things. I
Yes,
find that,
and-
those things can be very confusing for somebody outside. Withdrawal, struck off roll, nolly prosecute. Basically, at the end of the day, they amount to the same thing, but the difference is the technicalities and at what stages and who makes those decisions. So a withdrawal, to start with a withdrawal is made only by a prosecutor. Only a prosecutor can withdraw a case. A case can be withdrawn provisionally, which means temporarily, or finally, which means it will be withdrawn, it will never be seen again.
So it's the end of the case.
It's the end of the case. So prosecutor will withdraw a case provisionally in an instance where the case has been coming to court a couple of times. We're waiting, for example, like I said earlier, for DNA. It's taking 4 months, it's taking another month, the court is getting frustrated. It's the only thing that is basically outstanding. The prosecutor can decide, you know what, let's get our house in order. We'll provisionally withdraw the matter. The accused person does not need to constantly come. Once we have the DNA, we'll place the matter back on the roll. That is a provisional withdrawal.
Okay.
A final withdrawal will mean we have the results of blood alcohol results. The results are 0-0. This person that the police thought was drunk because of his behavior is actually not drunk. The result says 0-0. We withdraw the matter in court. That is now a final withdrawal where the docket is now archived by the police. They do not work on it.
And struck off the roll.
So now struck off roll, there will be an order that can only be made by court. A prosecutor or defense attorney cannot strike the matter off roll. And a matter that is struck off, you can only strike the matter off the roll once it is on the roll.
Okay.
So it is ordered by a court where the court feels like, okay, the state is taking its time, these investigations are not finalizing, coming to conclusion, and the accused person has a right to a speedy trial. As the court, I feel, is prejudicial to the accused person, I'm going to remove this matter from the roll. I'm going to strike this matter from the roll. But it also has the same consequences. The prosecutor, once they have their house in order, once they have the DNA reports, can then re-enroll the matter.
Oh.
It's not a final decision, a struck off roll. Now, a nolly only happens outside court where a matter comes as a decision docket. And I go through the matter and I realize, okay, the allegation does not really meet the requirements of an offense here, or there's not enough evidence at this point for me to charge this person. I need you as an IO to do 1, 2, 3, 4, 5 before we enroll this matter. So at this point, I'm going to nolly prosecute the matter. Nolly prosecute meaning declining to prosecute at that time. And on nolly prosecute, once those investigations are done, you'll always come back.
You can still re-enroll the matter.
The only times where a matter cannot be re-enrolled once there's a trial and there's a verdict by the court.
Oh, great.
Yes.
Now, if maybe just one last advice that you can give to someone who's unhappy about the manner in which their case is being handled, what recourse mechanisms are available for them, or what is it that they can do? Who do they talk to?
Speak with. There's formal ways in which you can go about it, and then there's informal ways in which to go about it. And in case of you do not appreciate how the investigating officer is handling your case, you can go to the station commanders, and the police will then have their own channels. But your first point of contact will be station commander, who is the boss basically accounting
police
authority of the
that police station where you
investigating officer, because now you're not happy with him, then you have to speak with his boss. And then if you're not happy with the prosecutor, if it's a prosecutor in the regional court, you can ask to speak with a control prosecutor or the SPP, which is informally senior public prosecutor.
Yes.
Which is informally, but formally, if you want to make a complaint, you make representations, what we call in writing, to the senior public prosecutor to say, I'm not happy with whatever decision was made or whatever process are going on. If you're not happy with the senior public prosecutor's response, you can take it to the chief prosecutor. If you're not happy, you can escalate it to the office of the director of public prosecutions. If you're not happy, you can take it to the national director of public prosecution. So those will be now the formal channels where you can complain. But as I always say to the complainants, always speak up. If you do not understand, ask questions. If you're not happy about something, speak up, because you can realize it's just a matter of misunderstanding and misinformation.
Okay, thank you so much, Advocate Phatlanyane.
Thank you so much for having me, Phindi.
This was very insightful. Maybe let's just recap in terms of the roles in closing.
Yes.
You said a matter is reported to the police.
Correct.
They open a docket, it gets allocated to an investigating officer. From the investigating officer, it gets to court. A prosecutor then takes a decision. It is brought as a decision docket, right?
Correct.
Thereafter, a prosecutor will then decide whether they prosecute or not.
Yes.
And then if it is prosecuted, it goes to trial when it is trial ready. And then ultimately, who then decides on the guilt or the innocence?
Then the final decision will be the court, the magistrate or the judge.
Or the judge.
Yes. So from the police, prosecution to the judiciary.
Oh, okay.
Yes.
So it is that value chain.
That is, yes, correct, Phindi.
Of the criminal justice system. Thank you so much, Advocate Phatlanyane. And once more, thank you for making time to talk to our viewers. I hope that our viewers have found this discussion insightful. That is all that we had for today. And please do remember to follow us on our social media platforms. We have our NPA TV channel, which is on YouTube. We are on Facebook and Instagram, the National Prosecuting Authority of South Africa. We are on X at the Twitter handle at NPA_prosecutes. That is all that we had for today. Remember to tune in to our next episode. And please, please do stay on the right side of the law. Thank you.